All right, so our first snippet for this week looked at gender issues in the law in the and politics in the late 80s, early 90s. The second snippet that we have is going to look at sexual orientation and the law, which becomes a significant issue at roughly the same time period. Um, with a kind of slightly different path with regards to public opinion, and in some ways, I think a firmer response from the courts. So this is a chart. This is from Gallup, asking people whether they think gay or lesbian relations between consenting as adults should or should not be legal. This is not same-sex marriage. This is simply whether there is whether gay or lesbian sex is criminal. And as you can see from the chart, until 1990, a majority of Americans said that it's perfectly fine for states to criminalize these acts. It's around 50-50 in the 1990s. It spikes up a little bit in the early 2000s, and now it's roughly 3-to-1. But in the period that we're talking about today, a majority of at the beginning of it, a majority of Americans are saying that it's okay for states to, and this is almost all these statutes, are targeting gay men rather than lesbians. That it's okay for states to criminalize, and there's relatively little popular support. The gay rights movement politically begins in the 1970s, but almost immediately triggers a backlash, mostly associated with Christian conservatives, of whom the most significant figure is this woman, Anita Bryant, a former beauty queen, a singer, a spokesperson for Florida orange juice, of all things. And in the 70s, there are no states that adopt anti-discrimination statutes as applied to sexual orientation, but there are a number of cities or counties that do so. And Bryant originates a tactic which then will be used later on in the same-sex marriage debate, and as we'll see, was also used in the Romer issue, of going to the people and getting popular votes to overturn duly passed anti-discrimination laws. This is something that largely was not done with regards to African American civil rights laws in the 60s. I mean, sort of the haulback in the Jim Crow era it was done, but largely was not done in the 60s, with the exception of the Rumford Act, which we looked at in California, and generally was not done on gender matters as well, but on sexual orientation matters. This was almost always the pattern of opponents of these laws. And there are a variety of reasons for this, but the obvious one, I think, is largely correct, which is that the main objections to these laws tended to be either just animus against gays and lesbians, or sincerely held religious objections, both of which are not really compelling arguments for a legislature, but in a public vote, it's hard to police what's going to motivate how people will vote. So there's relatively little political progress for gays or lesbians from the 70s into the 1980s, with the exception of states that do strike down, or excuse me, do repeal or have their state courts strike down laws that criminalize gay sex. So this is a map that sort of shows the progress of this issue. The states that are in bright yellow, Illinois is the first state to repeal its law criminalizing gay sex, or in this kind of goldenrod color are states which make their repeals by the end of the 1980s. And so basically laws that continue to criminalize gay sex remain in place throughout the South, and also in states, Maryland, Rhode Island, Massachusetts, Michigan, to a lesser extent Minnesota, that have a significant Catholic population, or Arizona, Utah, Nevada, Idaho states have a significant Mormon population. But there's a clear movement as more gays and lesbians are living openly, at least to get rid of these laws. But it's a critical goal of the gay rights movement to have laws criminalizing gay sex struck down as unconstitutional, not because these laws are usually enforced. They almost always are. They're very, very rarely enforced. But because they basically serve as a template for allowing discrimination in the civil matters. For instance, like in jobs, if you're a business and you don't want to hire a gay employee, or you want to fire a gay employee, say in the 1980s, you can always turn around and say, well, my state says it's okay to criminalize someone, if they're gay and they're having sex. So certainly, I have no obligation to employ someone who is engaging in criminal behavior. So this is the primary goal of the legal goal of the gay rights movement at this point, is to get these laws struck down. And they think they have a perfect test case out of Georgia. Very strange case where a man named Michael Hardwick is in his home. He had, I think it was a parking ticket. It was a low level offense. He didn't show up in court because the summons had been mailed to the wrong address. So the police officer comes to serve the warrant. The police officer enters his home. The door was open, and Hardwick is there, in his bedroom, having consensual intercourse with another man, and is arrested under Georgia's law, which criminalized homosexual sex. And this is a great case, it seems like, for the ACLU, which was looking for a case to strike down these laws, because here you have someone who is an adult, who is having consensual sex in his home, and the police, arguably entered it improperly. They sort of had all their ducks in the row. Very, very sympathetic plaintiff. They're relatively confident that they're going to win, and instead the case goes to the Supreme Court in a case called Bowers versus Hardwick. In 1986, the court upholds the Georgia law. The vote is 5-4. Justice Powell, who we were talking about last week in some of the discussion sections, originally is inclined to vote with Hardwick, but then flips and votes for the state of Georgia to uphold the law. The majority opinion, which I've clipped here from Justice White, says that there's no right for gay people to have sex in the Constitution. It's simply a misreading of the Constitution to suggest otherwise. And the concurrence from the Chief Justice is a vigorous defense of anti-gay statutes, and argues that moral objections to homosexuality, you can see this area that I have here in red, are sufficient sufficient rationale for a state to pass a law restricting the rights of gay and lesbian people. As we'll see, this case is ultimately reversed by the Supreme Court in 2003, but it remains good law through the late 80s through the 1990s. And the assumption is that as long as Bowers is going to stay on the books, it's hard to imagine courts issuing opinions, in favor of a gay rights position elsewhere. But it turns out ultimately they do. The most prominent example of this is the case that we read for this week, this Romer versus Evans case, which we'll be talking more about in discussions. But the result here is it's sort of similar to the Anita Bryant model that I had mentioned earlier. There are a handful of cities, liberal cities in Colorado, Aspen, which is sort of a ski resort, Boulder, where the University of Colorado is, and Denver, the state's largest city, very, very liberal, which had enacted laws preventing discrimination in the workplace and in public accommodations on the basis of sexual orientation. Colorado today is a basically safe blue Democratic state, but in the 90s, it's a very sharply divided state with this liberal, kind of a liberal minority and a very, very conservative, Christian conservative minority as well, and then kind of this middle group that swings between the two parties. And the opponents of these gay rights statutes get an amendment on the ballot called Amendment 2, which states, I've got it quoted here, but the basic effect of it is to say that cities in Colorado or the state legislature cannot enact anti-discrimination statutes. The only way that they can be enacted is through a popular vote of the people, and this, in something of a surprise, passes by around 7 percentage points. It's immediately challenged. It eventually works its way up to the Supreme Court. This is a different Supreme Court than the Planned Parenthood court because of Ginsburg and Breyer. So here there are 4 justices: Breyer, Ginsburg, Stevens, and Souter, who it seems pretty clear are going to be on the side of the gay rights challengers. Souter, although he was a Bush nominee and sort of voted moderate his first couple of years, very quickly moves to the left. There are 3 justices, Rehnquist, Scalia, and Thomas, who seem sympathetic to the proponents of Amendment 2. Indeed, there's nothing in their jurisprudence to suggest they're going to have a pro-gay rights position. The question is, what are Justices O'Connor and Kennedy going to do? O'Connor had voted in favor of Bowers versus Hardwick, so she seems like a vote in favor of Amendment 2. Kennedy is a wild card. He had written a couple of opinions as a circuit court judge that seemed somewhat sympathetic to gay rights. It's not entirely clear. After oral argument, it's clear that both Kennedy and O'Connor are deeply troubled by the Colorado law. And let's take a listen to the exchanges. These exchanges between a guy named Timothy Tinkovich, who is now a federal appeals court judge based ironically in Denver, and Justices Kennedy and O'Connor, where both of the justices are making clear that they don't really think there's a justification for Colorado's law.
The rationality of the substantive policy judgment that has so far motivated Congress and other states in deciding not to extend Title VII protections to homosexuals and bisexuals similarly supports the decision of Colorado to reserve that question to itself on a statewide basis.
It may be, counsel, that we have to reach that question, but it seems to me there's a predicate or a preliminary matter that we ought to discuss at some point during your oral argument. Usually when we have an equal protection question, we measure the objective of the legislature against the class that is adopted, against the statutory classification. Here, the classification seems to be adopted for its own sake. I've never seen a case like this. Is there any precedent that you can cite to the court where we've upheld a law such as this?
For basis of this appeal, the Colorado court did make an interpretation that, at least to the extent that it preempted local laws and state provisions, that's all the farther it went.
Well, does it mean that homosexuals are not covered by Colorado's laws of general applicability?
No, it does not.
How do we know that? I mean, the literal language would indicate that, for example, a public library could refuse to allow books to be borrowed by homosexuals, and there would be no relief from that, apparently.
So again, you can get a sense of what the justices are thinking here. If you have a justice like Kennedy saying, "I've never seen a case like this," he's probably not going to uphold the law. And then O'Connor, just as we heard her in the previous snippet in the Pennsylvania Planned Parenthood case, where she's trying to say, all right, let's look at this law and let's try to imagine how far can it go. Here she's suggesting that state agencies would be allowed to sort of discriminate in arbitrary ways against gay and lesbian citizens, and they'd have the citizens would have no recourse to the state. So the result is the 6-3 decision, Romer versus Evans. We'll be talking more about this in the snippet, so I won't cover it in any detail here. Here's the key excerpts from the Kennedy majority opinion, saying that the law is based in animus, and that in very famous line, a state cannot deem a class of persons a stranger to its laws, and a vigorous dissent from Justice Scalia, who strongly defends the rationale behind Amendment 2 and reaffirms the point that Chief Justice Berger made in his concurrence in Bowers versus Hardwick, that it is perfectly reasonable under the Constitution for states to adopt laws restricting the rights of gays and lesbians simply as a way of expressing moral disapproval of homosexuality. But Scalia's on the losing side here, even though ironically Bowers versus Hardwick technically remains good law. There's one other issue that legal issue with regards to gay and lesbian rights, which emerges during this period, and that's same-sex marriage. Which in 1996, a few months after the Romer decision comes down, is tentatively approved by courts in Hawaii. It turns out that Hawaii, this decision will be preempted by a constitutional amendment, so the decision is more or less annulled. But the concern that traditionally in the United States, when people get married, if you live in New York and you actually get married in New Jersey, your marriage is seen as valid in both New Jersey and New York. So the fear is that if among opponents of same-sex marriage is that if one state allows gays and lesbians to marry, in this case Hawaii, then all states would be compelled to recognize that marriage. And the result is the passage of a law that we'll be encountering again next week, called the Defense of Marriage Act. It's overwhelmingly approved by both houses of Congress and signed by Bill Clinton, which makes clear, as you can see in this excerpt that I have from the majority report, that it is based on moral disapproval of homosexuality. And what it does, for the first time in American history, it says that the federal government, which traditionally, states have minor variances with regards to their definition of marriage and have for many years. I mean, most infamous of this were states that banned interracial couples from marrying. But even today, some states will allow, second cousins to marry. Some states don't. Some states will allow people who are 16 to marry. Some states will be 17 or 18 years. There are these minor distinctions. There is no uniform federal definition of marriage under the law, but DOMA says that there is. And it says that the word marriage means only a legal union between one man and one woman as husband and wife. And so essentially what DOMA is saying is that if Hawaii legalizes same-sex marriage, and again, they didn't do this, so it ultimately, but it will have an effect a few years later when Massachusetts legalizes same-sex marriage, that if Hawaii had legalized it, you'd have this odd situation where a couple would be married under Hawaii law, for the purposes of state law, but for the purposes of federal law, including things say like income tax filing, they would be treated as strangers. And one of the more interesting aspects of the debate, which again is occurring just after the Romer decision, is this exchange between Henry Hyde, who is the Republican congressman from Illinois, chairman of the Judiciary Committee, and Barney Frank, who's an openly gay congressman, Democrat from Massachusetts. Frank is very, very sharp, so a good debater. And Frank asked the obvious question, which is, look, the Romer decision seemed to say that moral animus against gays and lesbians is not enough for a law. How, aren't you passing a law that's unconstitutional? And as we'll see, Hyde's defense is less than vigorous on this point.
But we're driven to this debate. We are driven to this debate by the courts. The Romer versus Evans case, which was decided May 20th of this year, is a fascinating case. And it provides really a preferred status for homosexual people and may very well invalidate a state's heretofore unquestioned power to reject the conduct in another state on public policy grounds.
Simply this, if the gentleman's interpretation, and I mean this quite seriously, if the gentleman's interpretation of Romer versus Evans is correct, and we don't know whether it is or not, but wouldn't that also apply then to the section here? In other words, if the court were to hold under Romer versus Evans.
Yes, the answer is yes,
so that this
could.
would also apply to this section equally.
It could, but that's why we need this statute, in my judgment, to give a little more leverage to the states. But
except, the gentleman, to 10 seconds, if in fact it's unconstitutional because of an interpretation of the parts of the Constitution, no statute would hold against that.
Well, maybe, maybe not.
This is the maybe not line of argument. It's really just, it's a quite extraordinary exchange. And as we'll see, Hyde's remarks and this report from the committee that Hyde chaired will be critical when the court ultimately overturns DOMA in 2013. So the key issue here is that that gay rights, which really just don't come before the court at all until the 1950s, and they're in kind of a very, very limited sense, suddenly burst onto the scene in the 1980s. And while the gay and lesbian movement suffers a significant defeat in Bowers versus Hardwick, the general pattern here is that on questions of gay and lesbian equality, gays and lesbians fare better in the courts than they do in public opinion. This, of course, is going to shift, and that's it for our second snippet.